Okay, so today we are closing this course of FIDIC course. It was FIDIC book, but we added some cases, and also we added this the procurement by FIDIC, procurement procedure by FIDIC, and the today also we'll discuss the differences between standard forms of FIDIC, GCT, NEC, standard forms of construction contracts, GCT, NEC, and FIDIC was also some hints about an American form of American Institute of Architects. Actually, this course of FIDIC we made different, or I made different, because I added many things about why we have this clauses like this. Because sometimes people who are not familiar with the standard forms or not familiar with FIDIC, they come and study FIDIC to know about contract management. At the case here also, it was like this. So after they study FIDIC, they like understand all forms of contract should be like this. But actually, this is not the case. And today also we'll see how the other forms can work with the similarities and differences. And when we know why it is like this, and we had some cases and some lawsuits and some cases of law describing and discussing why it is these clauses are added and what happen if these clauses are not there. So you become aware of the when you are dealing with FIDIC or any other form, even standard or bespoke. That's why we also add this today as requested. So today we will go through the multiple standard forms. And I have selected these forms, or I can say these types of the forms here and there with the FIDIC. So we have the FIDIC rate book construction for construction, and GCT. From GCT we have a form of standard building contract without quantities, and for NEC we have NEC engineering, NEC for engineering and construction contract, option C target contract with activity schedule, and from the American Institute of Architects we have this form. It's AIA document A101 2017 standard agreement between owner and the contractor for a lump sum contract or stipulated sum. Today is the last session, the 10th session. What we did in this course, we started with the contract life cycle, discussing the procurement procedure. Then we went through the rep book, parties' responsibilities, position of the site, resources and subcontracting, program and extension of time. I will go from the commencement date to the time for completion, taking over certificate and performance certificate. We discussed the payments and certificate, interim payment and final payment, and payment and interim payment, IPC at completion, variation procedure, the claims and determination, how the engineer has the role here of contract administration to do agreement or determination. Then we discussed the cases of suspension by employer, suspension by contractor, and termination, also termination by contractor, termination by employer for convenience or for default, and optional termination in case of protracted exceptional event, which was before a force majeure in 1999. And finally, we went to the DAB, dispute avoidance and adjudication board, and arbitration. And then we have the two sessions, one for the yellow book, which is design, build, and lump sum contract, and today's session about FIDIC versus GCT and NEC. One of the things when we start a contract with a party, they call battle of forms. Battle of forms, it is like the people are arguing or discussing or debating what form will be used and how to select this form. If we will go to the FIDIC, for example, we may have the designed by employer. So we'll go to the rep book, which is a remeasure contract. We have also the bank for the developing bank. Then we have cases like the design that is MEB and including some commissioning work, and it will be going to the yellow book, which is which have the it is design build and lump sum contract. We have also the short form for the green for the short duration and the small amount, and we have the silver book, which they call ABC, and this silver book, it is without an engineer. So when you go to the silver, it is a book only for the between employer and contractor, and all rules are with the employer and no engineer mentioned there in the silver book. So the balance there in the silver is not like the other forms of yellow and red. And we have also the golden for BOT contracts, which is build, operate, transfer. And we have other forms of FIDIC, a part of this, like the not related to construction, which like the consultant, subcontractor. We have also this dredging standard form. So we have other forms also for the FIDIC. For the GCT, they have plenty of forms. That's why they have a document, full document like this, to how to decide the appropriate form and select the appropriate GCT contract. And if we'll go to these forms, we can find many forms are there. They are using some traditional, some design build, and other forms. So it is difficult and complicated a bit. That's why after a while they found the GCT, it was like the most used standard form in UK, for example, and then they found it like a bit complicated, and they decided to develop like a more modern and new engineering contract, this NEC, to simplify many things they found in the GCT after some reports. And they started using this NEC 4 for engineering and construction contracts, and now it's used in UK for the governmental contracts, and it's also developed to be an international standard form. When we see, for example, in 2018, I think the case now is different. The GCT was the most used contract, and they started using NEC. I think NEC now is increasing. Then they have some bespoke, and then FIDIC and other forms like RIBA, Royal Institute of British Architects, and other forms. And for the mechanism used, we can find there also in this time the fixed price or lump sum contracts are the most used contract, like 81%. Then the remeasure, target, and cost plus at the end. I think in our region we may use at most of the or many of projects I joined, it was like remeasure. So remeasure here it can be used more than the lump sum sometimes. These are the selected forms, what we are going to compare to check the major differences between these forms, which are the FIDIC rep book, the GCT standard building contract without quantities, and NEC engineering and construction option C target contract. To know about these three entities, the FIDIC, GST, and NEC, started in 1913. A number of consulting engineers met in a fair and they constituted the FIDIC, which is International Federation of Consulting Engineers. And it started by having the members of the entities representing the consulting engineers from the different countries around the world. And now they added some certificates recently for the engineer, like contract management and such things. The GCT, it started in 1931, so it's after FIDIC, but close to it. It's the Joint Contracts Tribunal and formed by the Royal Institute of British Architects. So it's by RIPA, and while RIPA, they have their other forms also, additional to the GCT. The NEC is the recent one, and it is by ICE, Institute of Civil Engineers. And actually, ICE, they have standard forms before FIDIC even, and I think FIDIC started from there. And it started based on some reports happened in UK, which is the Constructing the Team by Sir Michael Latham and the Sir John Egan, Rethinking Construction. And you can find many helpful things in these reports, and this participated in developing the forms of the contracts and the NEC new engineering contract. And I think you can find these reports free on the internet. You can download them and read them. How we are going to compare between these forms, we will go to main things, the structure and drafting, how everyone look, the pricing and scope there in these contracts, the administration, the role of contract administration, it's by whom and who can do instructions, quality and inspection, payments process, program, how the program, the time schedule is there in these forms, claim and variation, and finally dispute resolution. And then we will go quickly about the terminology differences with AI and some key differences also. For the structure and drafting, we can find the FIDIC 2017 general conditions includes 21 clauses, as we discussed in the course, and these clauses include some sub-clauses, and we can find this, they made this rainbow suit from 1999, the first version, and second version in 2017, to make the red, yellow, and silver, like with unified, almost unified main clauses, to be easy for the contract administrator who is using one of these forms can use the other one easily and can navigate it also easily with sub clauses. And it was like starting from this 1999, they summarized the clauses. It was before more than this, and they summarized and put it like in main and sub clauses to be easier and in the structure, and to be in a better structure actually. And also they introduced the DAB. We will go to it in the end for the dispute adjudication or dispute avoidance and adjudication boards. This is for the general condition. Then they have the particular conditions. And in 2017, they made these particular conditions two parts. One of them is the contract data for the parties to fill the data of the project, and the other one for the special provisions. And these special provisions will be like if you want to make any amendment to the contract, so you make it here under the special provision, like you want to amend something in a sub clause, you want to omit or remove subclause, you want to add additional ad hoc subclauses. And you need also to follow the golden principles to keep the balance and appropriate risk allocation, and also in the terms to follow the terminology in terms of drafting and clearing using clear structure. In FIDIC, you can find many clauses are incorporated by reference to the main one. For example, you can find many clauses are referring for procedures of variation, or referring to a claim, or referring to extension of time claim. So you can find inside each clause that this clause can refer to another clause. And when you go to the other clause, you find it referring to another, some other clauses. And if you are not familiar with FIDIC, you may go to loops inside the contract to understand it in the beginning and be familiar with it. FIDIC uses terms like shall, and they are saying shall means must. So why they are using shall, are not using must? Uh, so they are using shall, and saying shall means obligation and it means must, and may means it's something optional, or in case of rights, they are using may. GCT also is similar. They have they have agreements, including recitals, and then articles and contract particulars, attestation. Then they have conditions in 9 sections, and finally schedules. Most of clauses also incorporate other related clauses by reference. So you can go also to similar loops, and it can be more difficult in GCT because also the clauses are not similar from a form to form like what they did in the Rimbo and FIDIC, for example. GCT also uses shall and may. NEC changed this scenario. They uses core clauses, dispute resolution options with some secondary options in the contract, and the cost components in the contract data, and that clause for amendment. They are writing more, trying to make it more simple, straightforward, simple English. They are not referring to in each clause referring to other clause and making loops in the contract. They try to make everything inside each clause and not referring to other clauses. They don't use shall and may. They said contract is for obligations, so they use does and may. So once a party will do something, the contract is mentioning the party to do something, it means an obligation on this party. It means this party must do this thing. So they are not using shall in the meaning of must, and not using must also, they are using to do something. And they are using may also in case of optional rights. If we'll go to pricing and scope, this form of the rep book is a remeasure contract. The design is by employer, so we have a bill of quantity, and the payment will be based on the actual quantities done on site. So we have measurement, and the payment will be according to the measurement. The design in this rep book is by employer, while the yellow, for example, it's design built by contractor in the yellow, and the yellow is lump sum, not remeasure. And we have forms as discussed in the beginning for BOT, build, operate, transfer, consultancy, and dredging. The scope is defined as works. So the scope of work is called works in the FIDIC with W capital. The terminology of the FIDIC they are using, and the terms they are using, you'll find many words in the definition. They are using it with capital words, so it's initial with capital or uppercase letter, even if you are using this word inside the sentence. This should be described in the specification, drawings, and schedules, bill of quantity. Some of the work is stated in the letter of the tender, and accepted in the letter of acceptance as accepted contract amount. Also, provisional sum is allowed under the FIDIC under subclause 13.4. The GCT form here we are discussing is a lump sum measurement based on bill of quantity or cost reimbursed. They have also other forms with bill of quantity or cost plus according to the form used. The scope is defined also as works described under a section called recitals in the agreement after defining the parties. So it's defined in the beginning of the contract under this section. The contract sum is specified under Article 2. So we have here another termination used in GCT. It's called article. In FIDIC, normally we say clause and subclause. Here we have Article 2 in the agreement. Also, the provisional sum is allowed in the contract documents under clause 3.16 and to be valued as per clause 5.23. NEC, we have here also the option of lump sum, bill of quantity, cost plus or cost reimbursement, with additional option of target cost. So you can have a target cost, and then if the contractor will save for this target cost, like they will get incentives and it will be shared with this saving will be shared and will be shared for pain and gain. Scope and site information are defined in clauses 11.2, 16, and 18, which is described in the contract data, part 1 provided by the client. So here we are using client, while in FIDIC and ACT we are saying employer. Provided by the client, activity schedule in option C is only for pricing and doesn't represent scope. So we started having here like differences. We said here about the selection of the form and we have the golden principles need to follow when you are drafting. Here we have this, we selected this form of the NEC, which is engineering and construction contract. They have some options with activity schedule, with bill of quantity, with target cost, or cost reimbursement contract. The GCT also, they have, as we discussed in the beginning, many forms. To summarize it, we have some forms which is traditional forms with measurement or cost plus, and we have also forms for design and build. The administration and the instructions. Who will administer the contract? Who will do the role of contract administration? In the FIDIC, we have the engineer is doing this role of contract administration. The engineer in FIDIC doing two or many rules. We can say mainly two rules. One, to do like the quality, safety, inspection, these things as a supervision. And they do a role also of contract administration. And in the role of supervision and sometimes in instruction, they may represent the employer. While in the role of the contract administration, they should be fair and somehow impartial, which is challenging to play these two roles at the same time. The engineer may issue instruction necessary for works or variation. So in case of variation, they may issue this instruction on behalf of the employer. They issue notices, other communication, and this communication also between the parties or notices and communication between the parties shall be in writing as per subclause 1.3. In GCT, the employer assigns an architect or contract administrator. So we have here like an engineer but called the architect. So is doing also some role of supervision to administer the contract under Here, clause 3.5, contract administrator may issue instructions or variation. Instructions are allowed oral to be verbal orally in case of emergency under clause 1.7.5 or otherwise than in writing if it's not emergency 3.12, but this shall be confirmed in writing. So if you do something verbal or oral, it should be confirmed in writing. NAC, the administration rule here is different. Here the client, and as we said here, we have client, not employer. The client assigns a project manager to administer the contract, clause 14. This project manager may give instructions or notify compensation events. This is also one term here, new term here used in NAC. It's called compensation events. It will be used for claims after that. Verbal instructions are not mentioned in the NAC, but all communication to be in a form which can be read, copied, and recorded, which means to be in writing. The role of administration actually is a critical role and very important for the contract. And it's an obligation on this party to act impartially, to do things with fairness to both parties. This duty is to act impartially between employer and contractor. Otherwise, if the contract administrator doesn't do so, it is a breach of its duty. So it is a critical duty and very important not to violate and to be in a breach of this duty and to implement it fairly. And that's why, as we discussed in the FIDIC, with this challenge to the engineer to do both these two rules, the DAB is introduced. Quality and inspection. And the FIDIC engineer is responsible for supervision and doing inspection, as we saw in the FIDIC, under subclause 7.3, and appoint a representative and can delegate responsibilities under 3.3 and 3.4. GCT employer appoints a clerk of works to act as an inspector under the contract administrator directions, 3.4. NAC, it's here a different entity from the contract administration. The client assigns a supervisor. We have here an entity called supervisor to do tests and inspection or notify the contractor of defects in order to correct them. So this is different here in NAC. It is segregated, or it is separate now, who is doing administration and doing supervision. Payment process. For the FIDIC, we have clause 14 for contract price and payment. Contractor submits a statement, engineer issue interim payment certificate. So we have an interim payment application or statement. Then we have interim payment certificate. Then the employer makes the payment with reference to the date of the statement for the statement submission for the IPC, but for the final statement, it is from the certificate 56 days from the final payment certificate after the performance certificate. Performance certificate, it comes after the warranty duration, or what is called defect notification period, or it was before defect liability period. In the FIDIC, it is when we have the completion of the works. So we have a taking over certificate, then we have this defect notification period, and after that we have the performance certificate. This is the FIDIC and the types of the payment of FIDIC. Here in GCT, the payment process is managed under Section 4. The payment cycle is monthly. Due dates are referred not later than interim valuation, receive of also interim payment application. Then we have payment notice, and also we have final payment and final date for payment. We are following here the UK Acts, because GCT is almost can be like a UK form. It's used in UK. The valuation shall be done by quant surveyor, and contract administrator issue the payment certificate stating the calculation basis. The NEC, the payment process, section 5, based on defining the assessment date to determine the due dates for application for payment, assessment and correction, and we have final assessment and payment. The project manager decides the first payment, when we will have the first payment. Then it will be on intervals as stipulated in the contract. If it is monthly, it will be a monthly after that. So we have here some cases for the target cost and how this will be paid. The payment in FIDIC, we have before this timeline, each monthly or otherwise as agreed interim payment, it will be submitted to the engineer, receives a statement with supporting documents. Within 28 days, engineer issue IBC interim payment certificate. Within 56 days from the submission, the employer pay this to the contractor. The final payment is a bit different. The contractor submits a draft, then it is reviewed because this is final, so we cannot make corrections after that. Then the contractor submits statement. Within 28 days, engineer issue the certificate, the final payment certificate, and after this certificate, within 56 days additional, the employer makes the final payment. The GCT and NEC almost following the UK Construction Act, Scheme for Construction Contracts, and the regulations in 1998 and amended 2011. We have this case also discussed before, which is like a bit funny and very hard case, where the parties agreed it was a GCT form, and the parties with some amendments, the parties agreed to have a schedule of 23 valuation and payment dates only, covering the period of the project from September 2013 to July 2015, but the contract was delayed and not completed by that date. After that date, the contractor in August issued an application for further interim payments. The employer or the developer asserted that no further entitlement for interim payments. It's not allowed under the contract. Then it was referred to the court, and the court agreed that the contractor had no contractual right for interim application. So you can see how it is dangerous to have like such clauses in the contract. And we see also how it is not like we normally think. It is a normal procedure and it is normal right for the contractor to do this interim payment. And actually normally when I do any contract management course, I go to this principle for the simple form of contract. Or when you go to purchase something from the supermarket or hypermarket, you normally get the product and pay. And that's it, the contract is finished and closed. But we have a different nature in construction contracts. It takes a time. You don't see the product from the first day. So you need to add many things because of this. You cannot wait until you have the full project completed. You pay the contractor the full price and get the project. So it doesn't work like this. Because of this duration and the requirements of the cash flow, we added something called advance payment. For example, it may apply. We added the interim payments. We added the variation and how it works to make some changes to the contract with also some limitations on the parties and conditions. We added the extension of time mechanism, which so the change mechanism for variations, the extension of time mechanism, the payment mechanism. We added uh, many different things because of this nature of the contract and this duration. We added also mechanism for claims, for example, and for inspection, for many things to add it there until to complete the work and to make the substantial completion, as it's called by some forms, or completion of the works. And then we have the warranty durations, and sometimes by law we have this essential 10 years liability. Here the program, one of the things we have because of the duration. In the FIDIC, we have it is we have some key dates: base date, delivery of performance certificate, performance security, sorry. We have commencement date, date of completion, defect notification period, and performance certificate. In GCT, we have also base date, date of, like we call here, access, under FIDIC, access to the site position, completion date, which here we have something called practical completion. We have here the DNP called rectification period, up to certificate of making good. So you can see how the terminology here is different in many things. In NEC, the main dates are starting date. We don't have, it's not called here commencement or position. We have access dates. We have completion date, defect correction period. Here it was rectification period, here defect notification, and it was before defect liability period, up to defects date. Then we have here defects date. Here we have performance, here certificate of making good. So we can see what are the differences we have. Contractor in under FIDIC shall submit an initial program under subclause 8.3 within 28 days after the commencement. And we have may request the engineer can send a notice requesting a revised program after 40 to be submitted after 14 days from the engineer notice. And GCT contractor provides a master program under clause 2.9.1.2 and provides amendments within 14 days from CA decision without imposing any obligation beyond the contract. NEC, they are saying the program is in the heart of the contract. It is under section 3 time, the heart of the contract. It should be revised on a regular basis within the updates. The delay in submitting the first program allow the project manager to retain 25% of the payment or part of the payment. Claims and variation. FIDIC 2017 added this advanced warning added in 8.4. Claims and variation are managed under clauses 20 for claims and 13 for variation. However, the clauses entitled to extension of time are included in subclause 8.5, extension of time for completion, or incorporated by reference, as we saw in the course, how many clauses are referring to the extension of time, the clause of the subclause of extension of time. The valuation is coming under 13.3. The engineer determination is under subclause 3.7, which now called agreement or determination, which is starting by the engineer to consult the parties to get agreed, then to make the fair determination by engineer, then we can refer to the In case of dissatisfaction, we refer to the DAB. In case of for the DAB decision, in case of dissatisfaction, we have the amicable settlement and go to arbitration. GCT, the claims for time are under the clause of relevant events, while claims for cost are under the clause of relevant matters. So we can see here the difference between the events for time and payment. For the time, it's called relevant events. For the cost or payment, it's called relevant matter. While in FIDIC, we have one clause called for claims for payment or extension of time. And it was also made for employer and contractor under one claim or under one clause. The adverse weather included only as a relevant event, not relevant matter. So in case of adverse weather, the contractor will be entitled to extension of time and no compensation. The valuation rules depend if measurable work or contractor's design portion or day work clause. In NEC, we have early warning. Clause 15 is a tool for the parties to notify potential change or compensation events. Claim for cost or time are under the compensation event section 6. The contractor submits quotations which comprise change to price and or alteration to the accepted program. Then PM replies. In the FIDIC also we have the contractor submits the scope of work, the quotation or the cost of the work, and the impact on the time for completion. Then it will go to the agreement or the termination subclause. We may have in FIDIC, we may have variation by engineer's instruction or request for proposal. And we know the differences in the if it's decided to do or not to do, how we can have the contractor can submit a claim if he prepared the proposal and not the work not decided to be done. We may have under value engineering contractor's proposal. We can have also claims under clause 20 in FIDIC, and most of these things can go to the parties agreement or determination, and with valuation also by the engineer. Then if you have dissatisfaction, we go to DAB. If we have dissatisfaction, we go to arbitration, amicable settlement and arbitration. In the GCT, we have this relevant matter and relevant event. Relevant matter, it's for the cost. It's called here loss and expense. And the relevant matters includes variations, contract administrator's instruction, any default or act for omission, and addition to the contract. So in the relevant matters, it is for the in the relevant event, it's for extending the time for the project, notice by the contractor of delay to progress, fixing completion date. So here it's, you see the difference in the termination. They are calling fixing completion date to extend. We have a notice. Then this event is a relevant event, completion of works or any section to be delayed by this thing. The architect contract administration give extension of time by fixing such later date. Here they are calling it fixing completion date, not extending or extension of time. Here it's also extension of time, but they call it the process called fixing completion date, later date for completion works or section, as then estimates to be fair and reasonable. then you have the close of relevant event. In NAC, we have this early warning potential compensation event. Then the project manager instructs the contractor to give quotations. Contractor notifies the project manager gives the instruction to give quotation, then contractor submit quotations. Within 2 weeks, the project manager the response can be acceptance, or it can be to request to submit a revised quotation, or to make his own assessment, and contractor informs the project manager of assessment or decision not to proceed. So we can see here how the flow chart of the compensation event is different from the FIDIC, for example. The dispute resolution. When a dispute crystallized by unresolved claim or dissatisfaction on the unresolved claim in any case, this is like the definition of a dispute. Or in FIDIC, we have like dissatisfaction on engineer's determination and dissatisfaction on that. So we have a dispute. We'll go to the clause 21 for dispute and arbitration. It starts with to refer it to DAB first, if the dissatisfaction on the engineer determination, 7, or refer to DAB directly. Sometimes things can be referred directly to DAB. If no agreement, then the agreement can make a notice of determination or the agreement. In case of dissatisfaction, parties obtain DAB decision. If dissatisfaction, will go to the amicable settlement 21.5 and to arbitration 21.6. And we have here ICC, International Chamber of Commerce. Section 9 in JCT is settlement of dispute, starting with mediation in case of not resolved by negotiation. Then we go to something called adjudication. And the adjudication, it is specifically in UK, it is like it is mandatory in some cases of construction disputes. They go to adjudicator. And after that arbitration, accordance with the construction industry model arbitration rules, this is here the rules of the arbitration used in JCT, so similar to using ICC in FIDIC. And they apply the UK Arbitration Act, which is different from the ancestral. It's not like many countries are using the ancestral for. In NAC, we have some options to comply with international use. So it can be refer to adjudication or apply the UK Act. And in some options, they use dispute avoidance board. Here, the DAB is not like the FIDIC called adjudication, because in UK, adjudication, as I said, has its own procedure. So they have here the DAB called avoidance. And the FIDIC added this avoidance from in 2017. It was before only a dispute adjudication board, and now it is avoidance and adjudication board. And finally, they go to tribunal or arbitration. So we can find some similarities, or they are using the similar alternative dispute resolution approaches, but with their style and also some things related to the countries it's used. They use these forms like the UK law. In the FIDIC, we have this engineer determination, agreement or determination. We have the DAB decision. We have the amicable settlement. The parties shall attempt to do this, give a trial to make this amicable settlement within 28 days. And even if they don't make this trial, they can go directly after 28 days to arbitration. And uh, if they agreed to go to arbitration. In the GCT and NEC, GCT starts with mediation. NEC referred to the senior representatives of the parties. A party issue a notice of adjudication if adjudicator should act impartially and issue not agreed to refer to adjudicator go to tribunal or arbitration, which can be arbitration. A party doesn't refer unless referred to adjudicator, and this is also applying the UK Act. The DAB, Dispute Avoidance Board, in the NEC assist the parties to resolve the dispute before they become dispute. So something it is like in advance. The DAB also act impartially. The DAB visit the site, inspect the works, review the disputes, even if not formally referred. So they can make like visits. This is what FIDIC added in 2017. A party doesn't refer to the tribunal unless it has been referred to the DAB within 4 weeks from the DAB's recommendation. Here we have DAB recommendation because they are using for avoidance, while in FIDIC we have DAB decision. So like this, we discussed the main differences for these forms. The final thing we'll go to quickly to the American Institute of Architects. They have this A201 general condition, and they have some other forms. Construction projects governed by Federal Acquisition Regulation. So if you go to United States, you will hear this for many times. Federal Acquisition Regulation for contracts, used for contracts. And they have some other forms there. But when I asked there about like a common standard forms when I was in the US, I didn't find it. And also I didn't find this AIA is common. They are using like the forms, the government, like governmental forms. I think some governmental entities, they have their forms and they are using it. Not like what we saw in the UK, the GCT was the most used, and now NEC are getting more common there. But also to see how how one of the forms, American forms, are working. Here, this standard form of agreement between owner and contractor. So they are not here using employer or even client, they are using owner. So you can see from the beginning here the difference in the terminology. Owner and contractor, where the basis of payment is a stipulated sum, which is a lump sum. They have here the agreement, some clauses for the and documents for the insurance and bonds, and then the general conditions for construction. This general condition, we can find some key differences in the terminology, like when we are using UK forms, we say tenderer, while in American we say bidders, in the same meaning. We here in UK forms are saying sections and the clauses, while in American they are saying here in this form they're saying articles, and we found these articles also in GCT. They are saying employer, client. We have architect, contract administrator, project manager. Here we have owner in this form instead of employer and client, and we have also architect. We have the practical completion and the fixed date, for example. In UK, in the British, in the American, we have substantial completion and final completion. The FIDIC we call this completion of works or taking over certificate and performance certificate, for example. In UK, we are using program for the time schedule, which is we are using program double ME. And the American form here, they are calling it construction schedule or construction schedule. We have here relevant matter and sometimes for cost and relevant event for time and compensation event for NAC form. Here they have a change order. For example, if you go to FIDIC, you will have variation order. So, and this question I received from many people. What's the difference between variation order and change order? So now I can have the question also, what the difference change order, relevant event, relevant matter, compensation event, variation order. We have many terminologies used in different standard forms. And these terminologies, we cannot argue and make a special meaning for each terminology, like to be applied for everything. No, we need to see what form we are using, where it is used, the definition inside this form or in this case. Because, for example, sometimes, and this is we learn from the language, sometimes you have the same word used by engineers and used by doctors and maybe used by lawyers. And when you go to each specialty or each industry or profession, you will find different meaning for this word. While it is exactly in the same word in English or in the language, whatever the language is. So it is from that thing you need to follow your contract terminology and use it by the meaning inside your contract. So for example, if you are using NAC, you will use compensation event. If you use FIDIC, you will say variation order. If you use this IA form, you will use change order. If you are using JCT, you will use relevant matter for the cost or payment and use relevant event for the extension of time. In the disputes, we are going to senior representatives, mediation, adjudication, dispute avoidance, or tribunal. We have the FIDIC. We have this after the engineer determination. We have the amicable settlement and arbitration. In AIA, we have initial decision, mediation, and arbitration. And here they are following the AA for the arbitration under this form. And one of the things we have, if we go again to the change order and change management in construction here by ACE, Association of Advancement of Cost Engineers and the International, we have this recommended practice 100R 19 about this change. And we have two common types of hero change orders. We have something called directive or directed change. It's directed by the owner. So the owner make the change order, direct the contractor to make a change. So this is exactly like a variation order. And we have also another type of change is called constructive change. And this is causing a claim. Here in this case, you will have a claim. And in this, it's like some act or omission by the owner caused a change, but not by order or not by direction or not like deliberate or intention, a claim, a change, but it is, they call it constructive change. And we have the other type, what we mentioned is the directed change. So like this, we finished, and now we are closing, and we'll go quickly to what we discussed in this session. So what we discussed today, the differences between FIDIC, GCT, NAC, the difference in instruction and drafting, the pricing, the administration rule, the instruction, the quality inspection, the payment, the program, how it works uh, in each form, and how it can be extended under the claims, or also the variations, how the variation procedure will work. And we discussed the things like relevant event, relevant matter, compensation event, and finally the dispute resolution. And we checked the terminology differences with the so for going quickly about what we did, we checked these four standard forms from FIDIC, GCT, and NAC, and AIA. And these are the our special course of FIDIC. We check the forms in each one, how many forms we have, and what the types, what was the common types, for example, in UK in terms of cost and standard forms. And we went in details about these entities, how when the FIDIC started, the GCT and the NSC, like a new and simple, straight and more straightforward form. And we compared using these uh, main items, including the administration rule, the payment process claims, program claims and disputes. Like here, we checked how the NAC being more simple, using does and may instead of using shall, the pricing and the payments, also selecting the form and the options we have in each form, the administration rule here in FIDIC for the engineer, in NAC for architect or contract administrator. In NAC we have project manager separate from the supervisor. And this administration rule to act impartially, and the inspection here for the engineer, and here we have a clerk under the contract administration direction, and the NEC we have supervisor, a different entity. The payment process, how does it work? We check the FIDIC for the interim and final payment. We check the other forms using the UK Act, this case of how the agreement made it difficult for the parties when they agreed only on 23 payment dates. And we discussed the nature of construction contracts, why we have this additional mechanism, like here for the program and duration. We have payment mechanism, extension of time mechanism, a change mechanism, and we have this claims, how does it work in each one, the phases of the claim under the FIDIC, how it can be initiated and how it will be closed, and under the GCT for the relevant matter for the cost and relevant event for extension of time, and the compensation event, how does it work under the NEC form. Then the dispute resolution, the stages of or steps of procedure of dispute resolution, how we'll go for the ADR to the uh, arbitration or the litigation in some cases. Here the options in FIDIC, we're going to after the satisfaction and engineer determination, we have a dispute crystallized. Then we go to the DAB decision, amicable settlement, and arbitration. The adjudication and DAB and NEC, and with comparison, also some comparison with the GCT as well. And then the terminology of the IA and how is it different, tender bidder, section, clause article, employer owner, and program construction schedule. Uh, then the types of changes from ACE, and now we are closing. Thank you. Any question?
No, from me. Anyways, I will go through it once again, Yani, because
Is it?
Yeah, I
You
have to go
can
through
check
once again. Yeah.
Okay.
No issues. Anyways, you will send the PDF. I will go through it better. Yeah.
Yes, of course. And you have also the forms and the link if you
Yeah, I
wanna
have it.
get
I
these
already
forms.
downloaded that. Yeah. When you
Yes,
when you send the previous time, I downloaded.
yes,
I
very
already
good.
saved everything. Inshallah, I will go through it.
Okay, very good. And I'm available anytime if you have any question and you want to contact me.
Sure.
Don't hesitate to do so.
No, we already saved your number also. We will disturb you. Don't worry.
You're welcome. Always welcome. Uh, Jason, Varasan.
No, it's okay. Sorry for me.
Okay. Bye. See you and keep in touch. Thank you.
Sure, Mr. Majid, you too. Take care. And we will stay in
Oh,
touch also. Inshallah.
inshallah. All the best. Thank you.
Okay. Thank you so
Thank
much.
you.
Thanks for your
Thank you.
lecture.
Thank you.
Inshallah.
Thank you.
Okay.
Bye.
Bye bye.
Bye.